And I am from GA Investment Management, and I want to welcome you today to our first of the GA Investment Management Speaker Series. Today I have with us a young man by the name of Daniel Reimer. He is a very good friend of mine, and I've known him for a number of years. He is an attorney that we partner with. And Dan, he actually works with Abernethy and Hagerman in the Allison Park area. But we use Dan real often for wills and trusts and legal advice, things like that. And he generally works with our clientele. So today, I wanted him to talk a little bit about the Secure Act that was recently passed. He's very knowledgeable about it, and he's going to give you kind of a brief outline of the Secure Act, and we are going to field your questions. If you have any questions, you can send them to us throughout the program, and I will read them off and give Dan the question. He can answer it. So because this is the first of the GA Investment Speaker Series, we may experience some technical difficulties, but they are not out of our control. So we will proceed. Like I was saying, if you have questions, as Dan is explaining the Secure Act, you can put them into the text box or whatever it is, send them to me, and I will periodically ask him the question for you, and he will answer and field those questions throughout the program. Also, at the end, I think we'll take questions as well if you have any. So I want to introduce to you Daniel Reimer. His wife's name is Carol. He has a beautiful daughter named Hannah, and they live actually in the North Hills area. So here's Daniel.
Thank you, Dave. We just did the chair swap here. Well, welcome everybody. It's glad to be here to teach you a little bit about the Secure Act. Thanks to Cassidy, Dave, and the rest of the GA team for hosting and for letting me be a part of the training. This is a very important training because on December 20th of 2019, a very significant law was passed, the Secure Act. And as Dave mentioned, I want this to be interactive. So if you have questions, comments, don't be shy, dig in and we'll get them answered and we'll get them addressed. So over the last several decades, there have been rumors of the death of what we call the stretch IRA. The stretch IRA, if some of you are aware, is that strategy whereby if a person passes away, leaving the kids their IRA, the kids prior to December 20th had the choice and the option to stretch that account beyond their life expectancy. In other words, the kid would only have to take a very small sliver of the account over their life expectancy based on what the IRS expectancy tables were. Well, simply put, on December 20th of 2019, our government killed that rule, right? There is no longer a lifetime stretch except for a very limited number of exceptions, and we're going to talk about those exceptions. Now, why did the government kill the stretch IRA? Well, if you think about it, that money has not been taxed yet. So Uncle Sam has been waiting decades to get their tax dollars back, right? When you've passed away and you leave, your daughter $200,000 IRA, and she stretches it out over her lifetime, she's only going to pay tax on that little sliver that she has to take out. So the rest would continue to grow and compound and earn. So the government decided we need our tax dollars a lot quicker than we're getting them under the old rules. So that's what they did, right? They killed the stretch. Now, there's some good aspects of the Secure Act. The first is they've given us an extra year and a half at which we're supposed to take our RMDs out. What's an RMD? Well, it's a required minimum distribution based on the account, right? Generally speaking, it's about a 4.5% distribution that has to be made when you used to turn 70 and a half. Well, now they've extended that to the age of 72. Big deal, right? They gave us an extra year and a half to take the money out. Another good feature is that they allow someone who's still working and earning income to continue to contribute to their IRA, even beyond the age of 72. So those are good things. For younger couples, if you have a baby or adopt, the IRS is allowing us to withdraw $5,000 penalty-free from the account. And then the last area really deals with small businesses. They're incentivizing small businesses into creating and funding retirement accounts. Dave, do you guys do any of those? Do you guys manage any active retirement accounts?
Yes, we do. Majority of our business is management of active retirement accounts. Probably most of our clients are that have money with us that we manage are in retirement accounts.
Now, in the wake of the Secure Act, right, what kind of conversations are you having with people, if any, about the changes that the Secure Act made to being able to set up a retirement account and pool these small businesses together? Are you finding that clients are excited about the fact that now they can allow even part-time workers to start contributing to the IRA? Is that something that you're having a conversation with small business owners?
Well, we're having conversations with them, but it's interesting that a lot of that news has not gotten out yet. I mean, people are not privy to this information. It hasn't been circulated that much. So I think that was one of the real reasons why we had you come today, was to give our clients this information on a more broader scale rather than one-on-one. It's information that people know about the Secure Act, but they don't know what it is.
Right.
And so really it's been a one-on-one type of thing.
Okay.
We thought this would be helpful.
Yeah,
so it's a good question.
Good. Excellent.
Yeah.
All right, so again, these are the good provisions of the Secure Act. And so what are the bad provisions, right? When the government decides that folks older than 72 can still contribute to their IRA, when they've increased the required minimum distribution date from 70 and a half to 72, someone has to pay for those things. So in figuring out how the government is going to pay for those things, one of the biggest thing they've done is they've said that for all but a very small class of exceptions, when the kid inherits the IRA or the grandkid inherits the IRA, they cannot stretch it out over the rest of their life anymore. It gets stuck with something called the 10-year rule. That's the new norm now. For non-spouse beneficiaries, other than those exceptions that you're looking at on the screen, the kid has to liquidate the entire IRA out over a 10-year period. Now, you can imagine the tax consequence that might have, right? If your kids are in a high tax bracket to begin with, and then you're dumping a retirement account on them, that first dollar of their IRA might be hit at a very high marginal tax rate, 28, 30, maybe even higher. So that's how the government is getting these provisions paid for, right? They're taking the money quicker from your kids. Any questions about that? Anybody has? Okay. Now let's talk about the exceptions. So the first, of course, is the spouse. And just as before, the surviving spouse has the ability to roll the deceased spouse's IRA into their own and continue to stretch it over their lifetime. That hasn't really changed at all, okay? Now, where it does come into play with the spouse is, what if the spouse is in a nursing home, right? What if dad died and now mom's in a nursing home and the IRA beneficiary designation goes to mom? Well, guess who's going to get the money, right? The nursing home. So even though the wife gets the stretch, she doesn't have any asset protection. It might still make sense to talk about creating a trust, and we'll get into that in a little bit. Next exception is for a minor child of the owner of the IRA. Now, this is a unique one because it says that the kid can only stretch it until they hit the age of majority. Well, in Pennsylvania, the age of majority is 18 years. So if you've got a 15-year-old that's inheriting an IRA, for 3 years, they can stretch it out over their life expectancy, but at age 18, it diverts back to a 10-year stretch. So best case scenario, that kid's got till 28 to take the money out. The next exception is for disabled and chronically ill individuals. Now, who are they? As a general rule, these are folks that just can't earn a living, or they have a condition that is going to be very long lasting, right? They're unable to engage in gainful employment. For them, they still get the lifetime stretch. In other words, they can still stretch the money out over their lifetime. Now, what's the risk there? Well, often these people are on government benefits. And if they're on needs-based government benefits, giving them any money at all is going to be a problem for them. The last exception is for individuals that are less than 10 years, no less than 10 years younger than the IRA owner. So for those of you that have siblings, and your sibling is a couple of years younger than you, and you want to leave him or her the IRA, you can do that in a fashion where the 10-year rule will not be triggered. That sibling or that younger family member, as long as it's less than 10 years, can stretch out the IRA over their lifetime, okay? Again, what I see often is those siblings maybe not be so healthy, and you're going to wind up dumping money on someone that might be in a long-term care crisis. So that may not be the best approach. So those are the general rules with regard to spouse. Spouse still gets the lifetime stretch. Minor child up until the age of majority. Disabled and chronically ill individuals, and then someone that's not more than 10 years younger than the IRA owner. So these are the general rules as to who can still get that highly coveted lifetime stretch. Everybody else, right, every other kid, grandkid, they're stuck with the 10-year rule. Now, let me just say about the 10-year rule that it actually, the way the rule works is, and people have a misunderstanding about this, it's not that every year the kid has to take out 1/10 of the money. The rule is simply that by the end of the 10th year following the death of the IRA owner, all of the money has to come out. So you might have a kid that says for the first 10 years, I don't need money from the IRA, I'm not going to do anything. Well, by the end of the 10th year, that money's all coming out and they're going to get hit with a rather significant tax bill. But when you think about it, there's actually an 11-year period where you can take withdrawals. Why do I say that? Well, nobody dies, well, maybe some people do. Most people don't die on December 31st, right? They die sometime during the year. So if I pass away in July of 2020 and I'm leaving my IRA to my daughter, Hannah, Hannah can withdraw the first chunk of it in 2010 or 2020 up until 10 years following the date of my death. So she'll be able to take 11 withdrawals on an annual basis if that's the way she wants to do it. And this is where accountants, trusted financial advisors are going to come into play, because when that kid's sitting on a big chunk of money and they need to determine and ascertain when it's time to take the money out and be subject to tax, you're going to want to make sure you have some trusted advisors that can help you make those decisions. Okay, so conduit, right? Now that the Secure Act has passed, it has really, I don't want to say blown up, but it has changed in a very significant way the way lawyers have been treating retirement accounts. I've done a number of these trusts that are called standalone IRA trusts. The most common and popular is called a conduit trust. And quite simply, a conduit trust is a trust that simply says, all right, I'm going to create this IRA trust for my daughter, Hannah. I'm going to beneficiary designate the IRA to that trust so that when I die, the money goes into this trust. It's to be managed for my daughter, Hannah, and the trustee must distribute the assets to her. That's what the word conduit means. It's a conduit between the IRA custodian, whoever has the money, and the beneficiary. The trustee of the trust, the manager of the trust, has no discretion to withhold the money. They have to make the distribution to the kid. Well, what's frightening about that is now in the wake of the Secure Act, if you've got an old conduit trust that was built for you, there are no longer required minimum distributions. So if a trust says that that the trustee can distribute to my daughter Hannah what the government says is a required minimum distribution every year, then the trustee must do that. Well, there are no longer required minimum distribution rules for everyone other than those exceptions. So what could be catastrophic is the trustee of the trust doesn't make any distributions, and then after the 10th year says to the kid, hey, I got to liquidate this entire IRA, get ready for a really large tax bill. So if you have an IRA trust and it has conduit provisions in it, you may want to look at that again and make sure that it's going to work the way you want it to. Another reason that conduit trusts were popular, and I've done a number of them as well, is because of the asset protection that those trusts provide. Our retirement accounts are very protected from lawsuits, creditors, predators, not the nursing home, but from other creditors. Our IRAs are very protected. But when you leave it to the kids, they're not protected anymore. There was a case several years back called Clark versus Reimer, where the Supreme Court of the United States ruled that inherited IRAs are not protected at all. It's just another asset that your kid has exposed to creditors and predators. So it still might make some sense to create that IRA trust for your kids, recognizing that that hedge of protection will exist for them for that 10-year period, so that if they get divorced, if they get into a car accident, if they get sued, the money's in the trust and it's still protected. Okay, that's a conduit trust. Now, other pitfalls you may need to be aware of. What if, right, a conduit trust was created and a beneficiary is disabled or incompetent, right? And now you're leaving an IRA through this conduit trust to a beneficiary that might be on a needs-based government benefit like Medicaid or some other government or community programs that require that their asset level be quite low. That's a problem, because if the conduit trust says you must distribute assets to that person, then you've really kind of messed up their government benefits, and that's something you need to be very careful about. So back to like a typical example, pre-Secure Act. I'm 85 years old, I've passed away, I've left my daughter Hannah a $300,000 IRA. Before the Secure Act, Hannah could have set up that IRA with a stretch provision. She could have said to the financial advisor, yeah, look, my dad taught me that if I leave the money in the trust or I leave the money in my name and I allow it to continue to grow and compound, that over 20, 30, 40 years, that modest IRA is going to be worth, potentially $1 million or more, right? Based on market conditions and such. So that was the strategy that a lot of folks employed. And whether you created a trust or not, the client still had the ability to reach out to the financial advisor and say, hey, Dave, I want to do that stretch thing. So Dave's job would be every year to reach out to Hannah and say, Hannah, okay, we're coming to the end of the year. You have to take out 4% of that IRA this year. Great. But the rest of it continues to grow and compound. So there's still value in doing that, okay, for the beneficiaries that still can get the lifetime stretch. The problem as well under the Secure Act is the tax consequence that this is going to have. If you've got a $100,000 IRA that I'm leaving to Hannah, and if she decides to be smart about it and take out the $10,000 each year, well, she's going to get taxed on the $10,000, and depending on what her other income sources are, it's going to be a fairly decent chunk of money. And now that it's compressed into a 10 or 11-year period, those consequences are not going to be insignificant. Now, can we solve this problem? Well, the answer is yes. I mean, there's certainly ways we can solve the problems that are created by the Secure Act, solve the problem of greater taxation to the kids, solve the problem of maybe having to remove that hedge of protection that you wanted to give your kids with an IRA trust. But the real way of answering the question is you guys need to decide what's most important. Is asset protection important? Is it important that if you're leaving the assets to your kids that the ex-son or ex-daughter-in-law can't get at it, or if the kid gets into a car accident or they make a bad business choice, that money is still protected? If that's an overarching goal of your planning, then it might still make sense to create a trust for those assets, even if it's for only 10 or 11 years in your kids' lives. Because the alternative to that is you dump the money on them, they liquidate it, they cash the check, they buy the sports car, or they stick it in the joint bank account, now making it a marital asset. There's just no protection there. And maybe you don't care, but it's something that we need to do a deep dive on and find out what exactly it is you're looking to accomplish for your family. Let's talk about some strategies, right? One of the first things you absolutely have to do in the wake of the Secure Act is you need to review and go over with your financial advisor your existing documents. You need to know what they say. You need to know what the trust says if you have one, and how does it treat retirement accounts? Is it a conduit trust? Is it some other kind of a trust? Are your beneficiary designations updated on your retirement accounts, on the life insurance? These things are all coordinated in a way that, a lot of folks don't realize it. I do a lot of workshops and I talk to people about estate planning, and one of the most common misconceptions is that the will that you have governs all of your assets. But as Dave can tell you, that's just not true. The will only governs assets that are in your individual name when you die. The will does not govern an IRA or a life insurance or an annuity or a joint bank account. They only govern assets that are in a person's individual name. So you have to make sure that you review right now what your documents all say and what the beneficiaries look like, because that's going to determine what kind of legacy you're leaving when you leave the kids the inheritance. Okay. What are some of the options we have to address or to fix this quote unquote problem? Well, one thing that I think a lot of financial advisors, and I think, the folks at GA are doing, is they're encouraging clients to give serious thought to Roth conversions, right? Because if you can convert some of your taxable retirement accounts and make them in non-taxable, that might be a smart way to do that. It might relieve the tax burden on the next generation. Plus, it allows you some greater income streams as you guys are living your lives. And of course, our life expectancy seems to keep going up and up. I don't know that the COVID virus has necessarily done much to life expectancy tables, but in any event, we're living longer. That's the reality. And so a lot of folks, their instinct is to not take money from the IRA because it's been hammered into our heads from day one. Leave that in, leave that in, leave that in, never take it out. Well, the problem is, you might be leaving it to your kids and they're gonna be hating you for it because you're leaving them a huge tax liability now in the wake of the Secure Act. So it might make some sense to talk about some Roth conversions, some very strategic, intentional Roth conversions. Another approach, and one that candidly I think it has still a lot of meat to it, is something called an accumulation trust. It's a different kind of an IRA trust. Whereas a conduit trust said that the money had to come from the IRA, had to go to the trust, and the trust had to give it to the beneficiary. An accumulation trust is one that says the IRA must be paid to the trust, but the trust may distribute the assets to the kids. They don't have to distribute the assets to the kids. And the beauty of the accumulation trust is, even though the IRA has to come out at the end of that 10th year, it doesn't necessarily have to go to the kids at the end of that 10th year. Because if the trust is still owning the assets and accumulating them, then the trust becomes the taxpayer. Now, I get it. Everyone knows trusts pay higher taxes than individuals. That's true. When a trust earns income of about $12,950, that trust is going to pay the highest tax bracket of whatever it is, 37%. You and I don't hit that tax bracket unless we're making a lot more money than that. But here's the thing. In analyzing whether it still makes sense to keep the money in a trust that might be a higher taxpayer, you really have to compare what the kid's marginal tax rate is versus what the trust's effective tax rate is. Oftentimes, people think the trust, if the money stays in the trust is going to pay a higher tax, but it may not be the case. The kid's income might be such that the kid's actually going to pay a higher tax. So why not keep it in the trust and provide that asset protection for it? That's my philosophy anyway. So just to, again, go back, two types of IRA trust, the conduit trust and the accumulation trust. You can still create the conduit trust for the spouse. What most people do, I see it, and I think maybe there's a better way. Most people simply name their spouse as the primary beneficiary of their IRAs, right? Everyone thinks that. That's the way to do it. Well, I'd rather at least explore the possibility of naming a trust as the beneficiary of the IRA. I name your spouse the beneficiary in the trust, and I allow her, in fact, I force her, because it's a conduit trust, I force her to get the distributions every year that the government requires her to take. But the rest of the money, the principal, the balance of that account would not be considered an available resource should she wind up in a nursing home. It wouldn't be an available resource to creditors and predators. So I think that this new law is a better opportunity for folks to explore an alternative to just naming the surviving spouse as the beneficiary. There's a way I can build a trust for you to protect the balance of the IRA. Yes, I'll make the RMDs to the spouse. I have to. And that money is not protected from creditors and predators in the nursing home, but the rest of the money could be. So if asset protection of that is important, you may want to still give thought to, to creating a conduit trust. And then with regard to the kids, an accumulation trust might still make sense. So just to recap, the two advantages of the trust are, one, it provides that hedge of protection for your kids from creditors, predators, and divorce. And two, it could provide us with a great deal of flexibility in allowing us to either give the money to mom when dad passes away. We could sprinkle it among mom and the other kids. You could sprinkle it in a way where the kid with the highest tax bracket's not going to get IRA money this year. We'll give him money from the life insurance. We'll give the kids that has the lowest tax bracket money from the IRA because they're going to get hit with a tax bill when they get the IRA. Okay. Other strategies to deal with the Secure Act: ILITs, irrevocable life insurance trusts. They've become out of vogue the last 20 years because, frankly, not too many people have to worry about federal estate tax anymore. Right now, if you have, as a single individual, more than almost $12 million, and as a married couple, close to $24 million, you don't have to worry a lick about federal estate tax. I call it your lifetime gift coupon. There's just no federal tax liability unless your numbers are more than that. Now, Pennsylvania is different. Pennsylvania has this thing called inheritance tax, and I wasn't going to get into it. But the point is that irrevocable life insurance trusts were very popular as a popular way of getting money to the next generation, and it wouldn't be taxed to Uncle Sam. Well, because I don't worry about that anymore, what would an ILIT satisfy now with regard to this new landscape under the Secure Act? Well, back to the conversation of maybe taking more money out of the IRA and funding a life insurance policy, putting the life insurance in a trust, an ILIT, where the creditors and predators can't get at it, the nursing home can't get at it. These are ways that we can still leave an inheritance to the kids in a fashion that is going to be a little more tax efficient. And then there's this thing called charitable remainder trusts. I think these are going to become very, very popular. Now, we're not trying to force people that are not otherwise charitably inclined to make a trust like this, but if you are charitably inclined, you may want to give serious thought to creating a trust in a fashion where you can leave a lifetime, like an annuity stream of income to your kids with that IRA, with those assets. And of course, there's no tax because it's a charitable remainder trust. In other words, when you transfer the IRA into this trust, you get a tax break. And as long as the charity ultimately winds up with about 10% of the value of that account, then the only tax that will be paid are the kids' taxes when they get the distributions, and it can be well beyond that 10-year stretch, right? They could take it over their lifetime. So for clients that have a desire to leave a very long-lasting stream of payments to the kids, a charitable remainder trust may make a lot of sense, because at the end of the day, most of the money is still going to go to the kids, but you do have to leave some of it to the charity for it to qualify as a charitable remainder trust. Any questions about those? Anybody has?
In what case would you use the charitable remainder trust? As I'm thinking about that, would it be exclusively for very large estates, or would it?
Well, not necessarily. It could be just someone has a very large IRA,
all
right? And maybe they don't trust the kid with it. They don't trust leaving $1 million IRA to the kid. And so they create this thing called a charitable remainder trust, where every year the kid gets maybe a 4 or 5% annuity, right? A little amount of that sliver, but the rest of it stays in the trust. And that it forces the kid to stretch the money out versus him cashing it out when mom dies, leaving him $1 million.
That's interesting. Now, once you set that up in the charitable remainder trust, and let's say you have it set up to pay your children over a period of 30 years, can that ever be changed? Or Is it
No.
set in stone once you?
The amounts are set in stone. You can't choose as to what type of remainder trust it is. You could either do one called a unit trust, which would vary based on the account. Like, let's say it's $100,000 and it earns $5,000 for 1 year, and now the account's $105,000. That 5% income is going to increase if the value of the account increases. The other is called an annuity trust, and that's just an actual amount, fixed amount, $5,000 a year until the money runs out. So yeah, I mean, that's a good question. I don't think you don't have to be a Mellon or a Scaife to benefit, I think, from a charitable remainder trust, because it's just one way to get less money in taxes to the government.
And I thought by nature of the title, charitable remainder trust, that it was specifically if you wanted to give money to charity and that was it.
No, well, you certainly could do that.
Yeah.
But most clients that create those, maybe it's a couple without kids, right? They don't have anyone to leave the money to. So you would create some sort of foundation. But again, you're dead, right? Like, if you're dead and you're leaving all your money to charity, there's certainly no tax that you need to worry about.
Right.
The charity's not getting taxed and you're not leaving it in any of the kids. So this is just, I think, an alternative to worst case scenario. The kid has to take out the money in 10 years.
Yeah.
To the best case scenario, if you can protect that money and kind of gently force them to spread it out over their lives so they're smart with it.
And leave some to the charity of your choice.
That's right. Which can be changed, by the way. You actually have the ability to change which charity ultimately gets that 10%.
And who would be the trustee?
Whoever you decide.
Okay. So
yeah.
Could it be your financial advisor?
If you're allowed to be a trustee, absolutely. Right. Some financial advisors have a fiduciary, I think, prohibition to doing that. But yeah, you can name whoever you want to be that trustee.
Or your trusted attorney.
Right. Your trusted attorney. No pun intended. So those are just some things to think about. Again, I'll repeat this because it bears repeating. You got to reach out to your financial advisor and just say, hey, can we revisit the beneficiary designations on these accounts? I want to make sure we know where this money's going. Who's it going to? And if it's spouse going to spouse, you may want to have a conversation with me or somebody else about maybe protecting that IRA so that if one of the spouses dies, it's not just getting dumped on the lap of the other spouse. We can do some wonderful things with trusts. It's something I call inside and outside planning. So inside the trust, I'll have maybe like a family trust built. And the family trust beneficiary is mom. And mom's the only beneficiary of it. So every year she gets the IRA, RMDs, and the rest of it has to stay in there. And if mom passes, then the money goes into the kids' trusts. The kids got their own separate share trusts. We could do things like disclaimer planning where, okay, the primary benefit, this is where the outside planning comes in. The beneficiary form names the trust as the primary beneficiary. And then it names the wife as the contingent beneficiary. So dad dies. The IRA is supposed to go into the IRA trust. Well, what if mom doesn't want it to go into the trust? The trust could disclaim it. And then the beneficiary form says that the contingent beneficiary is mom, and then mom gets the money. And then maybe we have a tertiary where if mom disclaims it, then we take it down to the next level and we give it to the kids in their separate share trust. So there's a lot of really wonderful strategies that we can employ beyond just the typical, all right, spouse first and then kids 50-50. I don't want to say that's the common accepted form of doing this, but there's a better way, especially in light of the fact that long-term care costs are incredibly exorbitant, and they're not getting any better, right? The average cost of a nursing home in Pennsylvania is $10,732 a month. So if you have a desire to protect some of those assets, including the IRA, you really do need to think about at least looking at a trust as a way of doing that. And again, back to my point of the will only governs assets that are in your individual name. Make sure everything that you have is coordinated. Make sure the beneficiary designations line up with your wishes, because if your will says I give 80% to Junior and 20% to Sally, and the beneficiary form on your IRA says 50-50, well, there's a tension there. There's a conflict there. You've got to make sure you understand how each of these assets legally passes upon your death. And then if life changes, if circumstances in your lives change, it's always a good idea to just take a fresh look, to kick the tires off of those documents you did 15, 20 years ago. Powers of attorney are incredibly important documents. I would say take a look at those every 5 years, make sure they're still going to work. Okay. And I guess the last point on this is, don't confuse documents with planning. Anyone can get documents. Anyone can get them to you. You can get on the internet and you can download any kind of form for powers of attorney and wills and medical documents. But just because you have a document, that does not mean you have a plan. A document is more than that. Your family does not fit in every document, right, that's out there. A unique plan really accounts for what's going on in your kids' lives. Tell me about your son-in-law, right? Tell me about their business. Tell me about their health issues. Do they have any disabilities? You have to think kind of deeply in this. It isn't just a simple, what I call an I love you will. You really do need to make sure that you're digging a little deeper and peeling that onion back a little deeper to make sure that your goals and desires are going to be fulfilled. So what do I do next? Well, this really is the shameless plug for Dave. This is where I say, give your financial advisor a call, right? Have the conversation in the wake of this little webinar here. Say, all right, what's the Secure Act going to do to us? What's the consequence of it? Does it make sense to bring Dan into the meeting and let's talk about creating a trust perhaps? That's really the next step for you. And then talk as well with them about, does a Roth conversion make sense? And here's another idea. I mean, I can move a Roth into a trust without triggering a tax. So let's say a client has a $100,000 Roth IRA and they want to protect it from the nursing home. I can change the ownership of that Roth, and that $100,000 will go into this trust. Once it's in the trust, though, it's not a Roth IRA anymore. So you would invest it, Dave, in some fashion, and it would grow and it would earn. And the only tax liability isn't the tax from the Roth, because as you know, Roths are tax-free. The only time there would be a tax is if the money in the trust, now just being invested in some brokerage account, would actually earn income or dividends or something, and then the tax would fall on that. But I've done that a number of times for clients that they had smallish Roth IRAs and they wanted to protect it. I said, yeah, I can move it into the trust and protect it. You just have to realize it's not a Roth anymore and the money's not going to grow tax deferred.
Now, are all trusts taxed equally?
No, there's two very broad types of trusts. One is called a grantor trust. A grantor trust is one that uses your social security number for tax reporting. So the reason that it's called a grantor trust is if I give you enough control, if I give you enough of that string that attaches to you such that you have the ability to change who the beneficiaries are, you have the ability to be an income beneficiary, you can be trustee of it. That's enough control in such a way that the government says, in the eyes of Uncle Sam, that's you. That's just an alter ego of you. So any tax liability that would flow from the trust assets are going to go to you on a 1040 just like they would now. That's the vast majority of trust that I'm building for clients, because I don't care about federal estate tax anymore with the numbers that we have, 11.2 or 11.4 and what is it, $22.8 million. Unless you have that kind of wealth, I don't care about the rules that say you can't be trustee of your trust. Or that you can't change the beneficiaries and decide who ultimately benefits from the stuff. Because of that, I'm building a trust that gives you total control. What it doesn't give you is direct access. And that's maybe a conversation or a webinar for another day. But irrevocable asset protection trusts are one of the most powerful strategies that I've been using for the last 8 or 9 years to help clients protect from the devastating effect of a long-term care crisis. But it isn't as scary as you think. Even though it's irrevocable, it's still revocable under Pennsylvania law. Even though it's irrevocable, there's still changes you can make to it. There's still things you have control over. You just can't reach into that pot and pull the stuff back out to yourself. You've made the trust and your kids are the beneficiaries or your loved ones.
Yeah.
So that's the kind of trust I've built. Now, the other kind of trust that you alluded to is one in which it is its own taxpayer. It has its own tax identification number. That's a non-grantor trust. That's one in which people built in order to protect against estate tax, right?
Okay.
When you put money into that kind of trust, you're giving up all control, you're giving up all access, you can't take the income. You really are giving away the money. And because you're doing that, Uncle Sam says, well, then when you died, it wasn't yours anyway, so why should I tax it? So those are the two broad types of irrevocable trust. Now, there's also revocable trusts.
Okay.
And we didn't really touch on that. A revocable trust is really good for two things. One is it avoids probate. If you have a revocable living trust and you put all your stuff into it, your house, your bank accounts, your investments, well, when you die, the kids don't have to deal with the courthouse. There's no probate. Probate is a legal process that proves the will was valid, and it makes sure that the public is aware of the fact that you've died. Notices go out in newspapers. It's a very public, it's a very open proceeding so that anyone can come out of the woodwork and either make a claim against the estate or make a claim against the deceased. So a revocable trust avoids that. The other advantage of the revocable trust is it's just a better rule book for incapacity. If you become sick, your kids can step right up to the plate. Now they can manage the trust and they can do much better management, really, of the assets without having to rely on other documents like powers of attorney and such. So those are the broad categories of trust: revocable, irrevocable, and then the two dichotomy between the grantor trust and the non-grantor trust. For young couples, I often create something called a testamentary trust. It's a trust that I build within their will. So rather than dump a bag of money on the kids, the money's going into a trust for them, and it provides that hedge of protection from, the spendthrift kid. You give him a nickel and he spends a dime, or they're getting ready to be divorced. The money is safe. That's a testamentary trust, and again, that's a very powerful strategy to protect assets from the kids' creditors and predators.
And as you said before, you can even have your life insurance upon your death pour into that trust.
Absolutely.
Yeah.
You can, whether you move the life insurance into the trust now or whether you simply beneficiary designate it to the trust, it's putting that hedge of protection around it.
Because let's say you have $250,000 and you die and your kids are 15, 16, and 17. You may not want to leave them $250,000 lump sum.
And that'd be a disaster, right? So that goes into a trust, and you've got somebody that you trust to manage the money until they maybe hit a certain age, and then they can have control of it.
A lot of people don't think about that.
Well, and I think that's a function of a couple things. Nobody likes to think about death and dying, so it's not like something high on people's priority list. I saw a stat once that suggested that only 1 out of 5 families have any kind of an estate plan. And 1 in 5 of those is one that's going to actually accomplish the goals that they had. So that's a very low percentage of an effective estate plan. And the second is, a lot of folks think, all right, look, I'm dead. What do I care? When I die, I don't care who gets the money. I don't care what happens to it. It's their problem. Well, okay. But wouldn't you want to protect your kids from the grave? I know I would want to protect my daughter from the grave. It isn't about controlling from the grave. It's all about protecting from the grave. And these are some of the strategies.
Especially if they're very young.
And even if they're not so young, but even if they're, they're in their second marriage and Hannah's got a knucklehead husband, and I know for a fact when I die, he's going to serve divorce papers on her because he was afraid of me right while I was alive. Why wouldn't I want to protect that from walking out the door with my ex-son-in-law? So even if your kids aren't kids, there's still a value to putting that hedge of protection around the inheritance, in my view anyway. Great question.
Thank you.
Dave, anything more about the Secure Act that we need to cover? No questions from the people online?
No, I don't see any questions. I think just the explanation of it today has been very helpful to our clients and those listening and future listeners. I think that one thing that I need to remind everyone is that we have Dan. Any type of questions you have, anytime you want to meet with Dan, we can meet him here at the office. Yeah. You can meet at his office, wherever you'd like to meet. And there's no charge actually to get together.
Yeah, that's
talk
right.
about-
That's right. I don't charge for consultations, and if you're comfortable coming here, I'll meet you guys here. I'm not that far, so I like the idea of the team approach.
Yep,
You
we
know,
do too. And I think our purpose is actually to create that interest to be able to look at your situation and say, I never thought of that, or maybe this is something we should consider. Always to educate you first, and secondly to prompt you to ask the questions that are important and bring those to our attention so that we can help you with that in your plan. So
exactly right. So disclosure, right? Disclaimers. None of this can be construed as giving any investment advice or tax advice. Most of what we talked about was my opinion and my opinion alone. But I hope this was helpful. I appreciate, Dave, you bringing me in to talk about it.
And thank you, Dan. I appreciate it too. It was good talking to you. Very fine presentation.
Well, thank you, sir. Hey, we hope you enjoyed our time together, folks. Thanks for listening, and we'll see you soon.
Next month, I think we're going to do our second in the series on talk about Medicare and Medicare supplements and some things involved in that arena. So thank you, and have a great day. Thanks.
See you, folks.
Bye-bye.